Welcome to FTC's Education Blog. My name is Damon Wright. I'm the head of the Advertising and E-commerce Practice Group at the law firm of Gordon Reese. You want to build a company that's going to be around for a long time, that you also can enjoy. You can enjoy your success. You can sleep better at night. Your employees can feel better because they know their jobs are secure. So to that end, it's important to protect yourself from forces that could be disruptive to your business. So I want to talk about some simple, easy things you can do to accomplish that. First, let me talk about the Federal Trade Commission and how to prevent getting in trouble with the Federal Trade Commission. The FTC is enforcing a law very aggressively called ROSCA, R-O-S-C-A. It applies to businesses that sell products and services on a subscription billing model. So it could be subscription boxes, it could be flowers, it could be health and beauty, dietary supplements, informational products. The FTC goes after companies that violate ROSCA with a vengeance. They will have receivers appointed, temporary restraining orders entered, freeze assets. It's not much fun. It's much more fun as a lawyer to help companies avoid all that in the first place, and it's really easy to do. ROSCA requires three things. So imagine your checkout page. First thing is, on the checkout page, you need to have clear and conspicuous disclosure of the billing terms and cancellation terms. How much are people going to pay each month? And then the second is, you need to make sure the consumer is agreeing to those terms. They've elected to subscribe as opposed to buying via straight sale. So if you are selling a product via straight sale or there's a subscribe and save option, the consumer can check one box or they can check another box. They've thereby agreed that they want to subscribe. And the third thing ROSCA requires that there be an easy way to cancel, that people can send in an email to cancel or they can call a toll-free number. If they're calling in, they don't have to wait on hold for a long time. So if you comply with ROSCA, if you don't have deceptive advertising like fake testimonials, and of course if you keep consumer complaints low, it's very likely you'll never hear from the FTC. Let me talk about another force that could really be bad for your business, and that is consumer class action lawyers and serial plaintiffs. There are folks that spend their waking hours surfing the internet trying to find companies that are selling products that don't have some magic language on their site, because those are companies that are really vulnerable. You don't want to be one of those. The magic language, really easy. Again, on your checkout page, I agree to terms of sale, hyperlinked. And the terms of sale, of course, are a contract. By checking the box, the consumer's agreeing to the contract. And in that contract, in the terms of sale, two key provisions: class action waiver language and mandatory arbitration language. This means that a consumer is agreeing that if they want to sue you, they can't do it in court and they can't bring a class action. It has to be a single claimant arbitration. If you have this on your website, it's very likely that you will never face a class action, or if you do, you'll quickly be able to get the case kicked in favor of a single person arbitration. In 5 minutes of fixing the site, your site to add this, you can literally have saved yourself millions of dollars. So I can't emphasize enough how important that is. The last thing that could be really disruptive to your business is when you have a dispute with another business. Maybe it's a service provider, or maybe there's some type of revenue sharing agreement you have. You need to have clarity in your contracts. Penny wise, pound foolish. It made sense 250 years ago. It's still true today. Make sure your contracts are tight and make sure you are protected. Focus on these types of provisions. Representations and warranties. You want the other side to make representations and warranties to you. For instance, that they will comply with advertising law and other applicable law. Limitations of liability. You want to make sure that your liability is limited. The other side, not so much. You want to be able to get full relief from them if you have to sue them. And then indemnification. If they do something that causes you harm, you get sued because of something they did, you have the ability to go to them and say, you have to pay my damages. Again, having a sharp, clear contract will prevent confusion, disruption, and disputes down the road, and actually save you a lot of money in attorney's fees. So with that, you'll be on your way to having a stronger brand, becoming more valuable, having a place that your company's employees, again, feel secure working at, and again, enjoying your success and sleeping better at night. It's a pleasure to talk with you. Thank you very much. Take care.